All right, Katrina, who do we have first?
Your Honor, we have Ms. Hurd.
Okay. We are on the record, the People's State of Michigan versus Catherine Irene Hurd. This is file 21-0684FY. Would the attorneys please identify themselves for the record?
Joseph Amon on behalf of the people, Your Honor.
Daniel Duke of Bearing on behalf of Catherine Hurd for the arraignment.
Mr. Duke, may I address your client regarding the arraignment process?
Yes, Your Honor.
All right, Ms. Hurd, good afternoon.
Hello.
You're speaking a little bit soft. Can you hear her okay, Katrina?
You could speak
Yeah,
up.
I
That
see.
would be.
Can you hear me now?
Yeah, I can. Thank you. All right,
Okay.
Ms. Hurd, Mr. Duke is your lawyer for just today. If you wish to have a lawyer after today, then you either have to hire one or request a court-appointed attorney. Do you understand?
Yes.
All right, I'm going to share with you a copy of the document so you can see the charge and where I'm getting the information from. Then after I've read the information, all I want to know is if you understood what I've read. Mr. Duke will give you advice as to how you should plead to the charge. So in this case, ma'am, you are charged with 2 crimes. Just make sure of that. We really scan these in big today, so it makes it a little bit harder for us to read. All right, so you're charged with the crime of embezzlement from a vulnerable adult. It is alleged that on or about February 17th, 2021 to April 30th, 2021, in an address at 4124 Waldo Avenue in the city and county of Midland, that you did through fraud, deceit, misrepresentation, coercion, or unjust enrichment, obtained, attempt, or used, or attempted to obtain or use money owned, which is the property of Norma Maxwell. Get this over here. Directly or indirectly benefiting yourself, knowing or having reason to know that the person was a vulnerable adult, the money or the property having a value of at least $1,000 or more, but less than $20,000. If you're convicted of that crime, it is a misdemeanor punishable by up to 5 years in prison and or $10,000 in fines plus court costs, or you could be charged up to 3 times the value of the money or property involved, whichever is greater. And in count 2, you're charged with financial transaction device illegal use. It is alleged in the same date, time, and place that you did use a financial transaction device, knowing the device to have been obtained or held under circumstances prescribed or proscribed under MCL 75157N. That is a felony if convicted. It is punishable by up to 4 years in prison and or $5,000 in fines plus court costs. And count 3, you're charged with financial transaction device illegal sale or use. It is alleged in the same date, time, and place you did use a financial transaction device or attempt to have been obtained or held under circumstances prohibited under law. Again, that is typically a 4-year felony and or $5,000 in fines plus court costs. However, prosecutor's office is also alleging that you are a habitual felony offender. They have accused you of being convicted of a crime of larceny of building on October 15th of 2020 in Midland County, and on October 15th of 2020 of financial transaction device use without consent in Midland County, and on or about October 15th of convicted of financial transaction device stealing, retaining without permission or consent. That is also a felony. Therefore, any crime that I just read to you that has a maximum penalty of more than 5 years would make it a life offense, and any penalty I read to you that has a penalty under 5 years would be up to 15 years. So let's revisit that. The first charge, you were charged with a 5-year embezzlement from a vulnerable adult because of the habitual offender. That could be up to life in prison for you. Counts 2 and 3 are both 4-year felonies. So as habitual offender, you could receive up to 15 years in prison. Do you understand the 3 charges and the maximum penalties that I've just read?
Yes.
All right, Mr. Duke, do you have advice for your client as to how she should plead?
Not guilty, Your Honor.
All right, not guilty plea will be entered in the records of the court. There will be a probable cause conference set, in this case, on June 22nd at 1 o'clock. Preliminary examination, if we have it, will be June 29th at 3:45. Ms. Hurd, are you planning on hiring your own attorney or requesting a court-appointed attorney for your case?
I would like to request a court appointed.
All right, let me ask you a few financial questions. All right. On this sheet, I'm going to show you, this is the document that I'm getting the information from. I have 3 screens, so if I look at this main screen, I'm looking at you. If I look off to the left, I can read the document. So I don't mean to not look at you. Just it's easier for me to read this on this screen. So here it says that you have an address of 1905 South Sheridan in Bay City, Michigan. Is that still a valid address?
No, it's not.
Okay, do you have a valid address?
I've been staying at the Bay Area Women's Shelter. I use my parents' address for mail,
Mailing
but that's
documents?
it.
Was that your
Yes.
parents' address that I just showed? Okay, we'll leave that there.
No,
What is your parents' address?
1880 East Stewart Road.
Here in Midland?
Midland. Yes.
Is that 48640
Yes.
or 2? All right.
40.
Right. All right. So at this point in time, you're essentially homeless. You're living in a shelter. Are you single, married, divorced, or separated?
Divorce.
Do you have any minor children?
I do have 2.
Are they staying with you or do they stay with someone else?
They stay with me part of the time and my ex-husband part of the time.
Do you pay child support or do you receive child support?
No.
Are you currently employed?
Yes.
Where?
At Timber Tree Care.
What do you do for them?
I'm a groundsman. I help on tree jobs and split wood and just a lot of different things.
How much do you make per hour?
It's like 12 an hour.
How many hours a week, approximately?
Maybe 28, something around there.
20 to 30?
Yeah.
All right. Do you receive any type of assistance, food stamps, Medicare, Medicaid, or Social Security disability?
Not yet, no.
All right. I'm going to go ahead and approve a court-appointed attorney for you. Now we need to set bond. Mr. Duke, you make an argument for bond, sir?
Your Honor, it's my understanding Ms. Hurd turned herself in when she became aware of this particular warrant. She is employed and obviously she's very strapped financially, staying in a homeless shelter, but she continues to work. We would ask for a personal recognizance bond. I know the court's probably aware she is under circuit court supervision at the present time, so she is being supervised. I don't know about the exact timing of these incidents in terms of whether she was on probation at the time. It's a non-violent crime, and I think the personal recognizance bond is reasonable under the circumstances, including, like I said, the fact that she did turn herself in, so she's willing to take responsibility for what is going on in her life, and certainly was aware of this and wanted to get it taken care of.
All right. Mr. Amon, regarding bond.
Your Honor, we have concerns we have is she's on the delay right now for the 3 felonies that are listed in the habitual offender notice for similar acts just like this. So we have concerns about her taking advantage of vulnerable adults. So we'd ask that there be no contact with the victim in this case, no caring for vulnerable adults, no handling other people's finances or money or credit cards, no alcohol or drugs, and testing, pretrial services, and also any other standard bond terms. Thank you.
All right. Court Rule 6106F1 says, look at your prior criminal history. I show you have a 2010 drinking and driving offense out of Kentucky, a 2013 operating while intoxicated attempt theft of a motor vehicle registration plate, no insurance in Kentucky, and a 2020 conviction, which you're under a delay of sentence, which means you're on circuit court probation. I have no idea whether they know you are incarcerated right now in the jail. And taking that into consideration, your willingness to appear, obviously you once you knew about it, you did appear. You went to the jail first. They told you to come to the courthouse, and then we had you go back to the jail. So I do think that you would appear in court. The other issue is about risk to the community. So taking those things into consideration, I'm going to set bond this way. You may not leave the state of Michigan without permission of the court. You must appear in court for all things that you're required. You may not violate any laws. You may not have any control over anyone else's checkbook or financial documents or financial transaction devices. You may not be in the company of a vulnerable adult alone. You must not consume any alcoholic beverages, illegal drugs, or mind-altering substances, and that would include recreational marijuana. You're to engage in pretrial services. You're to get a biopsychosocial assessment done. If you've already done that, you just need to follow those rules and regulations with Ms. Rebecca Holm. Because I'm not certain about the circuit court probation, I'm going to set a $1,000 cash or surety bond right now. If she's unable to make the bond, I certainly will look at the bond on June 22nd, but I don't want her to out and then have to go right back in because of a bond violation. And so I am going to set right now a $1,000 PR or $1,000 cash or surety bond in this case based upon her recent interactions with the court, the fact that she was on probation or a delay of sentence, for the conviction. I don't know if she was under bond terms at the time, and I want to make sure that we have those things taken care of. So we'll be adjourned on this case at this time. She would have been sentenced when the allegations have taken place because it took place in 2021. So we'll be adjourned on this case at this time until June 22nd at 1 p.m. Thank you. We just have 3 this afternoon, Katrina, at the 2:30.
Yes, sir.
All right.
Your Honor,
Yes, Mr. Raymond.
I don't know if I missed it, but on her, did we put in there no contact with the victim?
It will be in there. I think I put no vulnerable adults, which would
Yeah,
by
I think-
definition include the victim, but we'll make sure it
Yeah.
says specifically the victim.
Well, I think you said without others present for those, and I just wanted no contact, period, with.
Contact. Yeah, that's a good one.
Perfect, thank you.
Name? Could you tell me your name, please?
My name is Daniel J. Corliss.
All right, Mr. Raymond, this is a city case, so it's probably not on your list.
I
Your Honor,
have
there's
also
also
an insurance case, Your Honor, no insurance.
You have a no insurance for him? Oh, I see it there. Okay,
Yep.
there's 2 cases.
Yes,
This is the people of the state of Michigan versus Daniel Corliss, file 210766OM and 210677ST. Would the city attorney identify himself for the record?
Your Honor, James Branson on behalf of the city of Midland.
And defense attorney?
Daniel Duke Capri on behalf of Daniel Corliss for the arraignment.
And prosecutor.
Joseph Fayman on behalf of the people for the county case, Your Honor.
All right, today's time and date set for an arraignment. Mr. Corliss, good afternoon. So your attorney, Mr. Duke, is here just today, just to help you through this arraignment process. If you wish to have a lawyer after today's date, you would have to hire an attorney or request a court-appointed attorney. Do you understand that?
Yes, sir.
All right, so let me go ahead and pull up the first case. All right, in this case, sir, you are charged with the crime of trespass. It is alleged that on or about June 3rd of 2020, that you were at an address at 4512 North Saginaw Road, formerly known as Woodland Place Apartments, within the city of Midland, without lawful authority after having been specifically forbidden to do so by the owner or occupant, agent or servant of the owner or occupant, in violation of section 1637 of the Code of Ordinances. If you're convicted, it's a misdemeanor punishable by up to 30 days in jail and or $50 in fines plus court costs. Do you understand the charge in this case, sir?
Yes, Your Honor.
All right, let's get the other one here. In file 21-0677, the prosecutor has charged you with the crime. Let me pull that up for you. In this case, sir, you have been charged with operating without security, which means insurance. The allegation is that on or about May 20th of this year, that you were operating a motor vehicle, a 2003 Honda Accord, which is a motor vehicle with which respect security or insurance is required by MCL 500, 3101, 3102, and 3104, 3103, and that you were operating that on Perrin Road, a public highway in the state of Michigan, without having full force and effect security, complying with the above statutes. If you're convicted of this crime, it's a misdemeanor punishable by not more than 1 year in jail and or not less than $200 nor more than $500. Do you understand the charge in this case, sir?
Yes, Your Honor.
Mr. Duke, how do you advise your client to plead to this charge?
Your Honor, after discussing the matter earlier today with Mr. Corliss, I believe he wanted to get everything taken care of today. He
So
said
you wanted to plead?
yes, he had indicated he just got some money this like yesterday, and he would be able to pay off hopefully all of his fines and costs on Monday by like 4 o'clock if he were to be released.
Okay. So, Mr. Corliss, my understanding is you want to plead guilty to both charges. Is that true?
Yes.
All right. Why don't you raise your right hand then? Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Put your hand down now. Has anyone promised you anything other than what we've talked about on the record or threatened you in any way to get you to plead to these charges when you really do not want to?
No, sir.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No.
If you entered this plea, you'd be waiving the right to a trial. You could have had a trial by jury, or if you, Mr. Duke, and the prosecutor agreed, or in the city case, the city attorney agreed, you could have had a bench trial. You will not have any trial at all. Do you understand that?
Yes, Your Honor.
Mr. Duke will be your attorney for this proceeding, and you'll be waiving the right to represent yourself or hire your own lawyer. Do you understand that?
Yes, Your Honor.
You'll be waiving the right to remain silent, not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
And you'll be waiving the right to confront your accusers, call witnesses, and to testify. Do you understand that?
Yes, Your Honor.
All right. How do you waive these rights to enter these pleas?
Yes, Your Honor.
All right. How do you plead to driving without security or insurance in file 21-0677 ST? Do you plead guilty, not guilty, or stand mute?
Guilty.
On or about May 20th of this year, were you driving a motor vehicle, 2003 Honda Accord, in the city and county of Midland on Perrin Road?
Yes, I was.
On that day, did you have insurance for your vehicle?
No, I did not.
Have I complied with the court rule and had an adequate factual basis, Mr. Duke?
Yes, Your Honor.
Do you agree, Mr. Amon?
Yes, Your Honor.
All right, I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. We'll enter in records of the court as operating without insurance. Before I go to sentencing, I'm going to take the other plea, but Mr. Amon, was there any restitution that was owed that I have to take into consideration?
No, Your Honor. He was stopped for speeding.
Okay. All right. So, sir, do you remember all the rights that we just went over regarding a trial?
Yes, sir.
Those also will be applicable in this case as well. Do you waive the rights in this case, the trespass case?
Yes, Your Honor.
And you remember you're still under oath, okay?
Yep.
All right. How do you plead to trespass? Do you plead guilty, not guilty, or stand mute?
Guilty.
On or about June 3rd of this year, did you go to Woodland Place Apartments in the city and county of Midland?
Yes, I did.
Had you been told prior to that date that you were not supposed to be on that property?
Yes.
And you went there even in spite of that warning. Is that correct?
Yes, sir.
All right. Mr. Duke, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
Do you believe so as well, Mr. Branson?
Yes, Your Honor, you have.
I believe so as well. I find that the plea's been made knowingly, understandingly, voluntarily, and accurately. Will enter record to court as trespass. All right, Mr. Duke, allocution on behalf of your client for both cases.
Thank you, Your Honor. At this point, we just ask you to impose the fines and costs in both matters. I believe Mr. Corliss understands he's not supposed to be going back to the apartment complex, and he was trespassed by the maintenance guy. There wasn't an issue with him causing, I don't believe, a disturbance with the residents of the apartment where he was visiting. It was more of an issue of his parking his car, and they didn't want him parking there, and different situations like that. And obviously, Mr. Corliss and the other case needs to make sure he has insurance on his vehicle before he's operating. But I think fines and costs at this point would be appropriate.
All right. And the argument regarding the, or was it the same argument for the no insurance?
Yes, Ron. It's a pretty simple matter.
Okay. Mr. Amon, any input from the people regarding sentencing?
We're good with fines and costs, Your Honor. Thank you.
Mr. Branson.
Your Honor, the concern about the apartment trespass is that I believe under this circumstance, he was pounding on a woman's door that he had no idea of. So he certainly scared a tenant that he did not know who was behind the other door. He was trespassed, and we would ask for any sentencing to be continued as a no trespass continuation at Woodland Place Apartments.
Okay. All right. Mr. Corliss, anything you wish to say in your own behalf?
I don't remember knocking on anyone's door except for my friends, my buddies. He was apartment 321.
Was it because you were high or drunk?
No, I was actually going to go pick him up, and I told him that I wasn't allowed at Woodland, and he said, well, park your car at Frick's. That's the problem. So I parked my car at Frick's, and I went to go walk over to go see him, and he had told me to walk back to my car. He'd meet me over at Frick's, and by the time I was walking back, the cops were already meeting me there, and the maintenance guy told me I wasn't allowed to be here, and I was like, I'm just being here for 1 second for my friend.
Okay, so you said friends. Tell me about your family. Do you have any siblings?
Yes, I do. I have an older sister, an older brother, another older sister, and a younger brother, and then I have half siblings as well in Indiana.
If I had information from them, what do you think that I would hear?
I'm sorry?
If I have information from them, what do you think that what they would say?
My brother would probably be concerned about me.
Why?
I'm sorry, because I haven't made very good choices.
How about your sister?
My sister is in Illinois. I haven't talked to her in a few days.
Amanda?
I'm closest with my brother. I'm sorry?
Which brother? Which brother?
Christopher's Corliss.
Would it surprise you that I got a letter from your brother that says that he's really concerned for your health and safety?
It doesn't surprise me. My brother and I love each other.
He says you got a pretty bad drug use problem, and he's really worried about you. Is that true, or is he a liar?
I would say, yes, I do have a drug problem, but I've been trying to find ways to go about it. I tried getting into the open door. I had to do an intake thing, and I ended up getting arrested and couldn't make it to that. I also took Hope Not Handcuffs, a bunch of pamphlets from some police officers. The only thing was my car wasn't insured, and I didn't feel comfortable bringing my uninsured car that has already been caught to the police station. So I didn't do that. Really,
So your sister also
honestly,
says
I'm
she's
trying to find help. I'm just like, nervous.
Sister says you're jobless, homeless, and losing your teeth to rot and decay. Is that true?
I am losing my teeth, yes.
Okay. Here's what I'm going to do, Mr. Corliss. It's because I have some concerns about if we let you out. So I'm going to sentence you this way. In file 210766OM, you were arrested today? Were you arrested today, sir? Or last night?
No, I was arrested last night.
When? I'm sorry?
Last night.
Last night? I'm going to sentence you to the city case, a $75 crime victim rights fee, no other fines and costs. I'm going to send you to 9 months of reporting probation. You're not to use any illegal drugs, alcohol, or any recreational marijuana. You're not to go to the Woodland Place Apartments. And you are to engage in counseling as directed by your probation agent, and testing to make sure that you're not using drugs. In this case, I'm going to sentence you to 30 days in jail with credit for 1 day served. I'm suspending all but 10 days. I want you to have an opportunity to get dried out and a place to stay, and I want you to work with community mental health. If you a community mental health worker to screen you to make sure that you're doing well. You have 21 days to appeal the sentence, 14 days to court appointed attorney. So you're going to be until about this time next week, I suspect. I want to make sure you get your head clear before you get out of jail. Then you got to come down to the courthouse and meet with your probation agent. In the low license case, I'm going to send you to $75 crime victim rights fee, $50 state assessment fee, $200 in fines, no court costs. You will be sentenced to the 9 months reporting probation, same terms as 210766. I'm going to sentence you to 1 year in jail with credit for 2 days. I'm suspending all but 10 days. It'll run concurrent with the other. So you're going to sit in jail for the next 10 days minus the 2 they give you credit for and any credit you'll earn. I want you to work with Marissa or anyone else that's community mental health inside the jail to get some things set up. We want a place for you to stay. We want to make sure that you're not using drugs. Your siblings have very much concern for you. They say that when you're not using drugs, obviously you're a much better person, and they're worried about you and worried about your health, and so am I. You have 21 days to appeal the sentence, 14 days to request a court appointed attorney. Mr. Amon, did you have a question?
Oh, no, Your Honor.
All right,
Your
Ms.
Honor,
Katrina.
just
Yes.
for verification, is that reporting probation or non-reporting?
It is for both. So once you get out of jail, sir, you're going to need to come down. And quite honestly, if you meet with Marissa and she says it has a place for you, I'll reconsider having that 10 days be 10 days. I just want you a place to go. I don't want you living in your car. I want you to have a place to stay. I want you to get some connections up. I'm worried about your safety. And if I let you out over the weekend, I'm worried that you would end up either in a hospital or a morgue. And I just wouldn't have that on my conscience. You're knocking on a door of somebody. You seem like a really decent individual. You're scaring the daylights out of somebody you didn't even know, knocking on their door, not knowing where you were. So talk with the people, community mental health, set up your plan for where you're going to go, where you're going to stay. And I will reconsider reducing that jail sentence. I just want you in over the weekend for sure to make sure that you got a plan. I don't want you just roaming the roads in the streets. Okay.
What if I have an address, like a place to go?
Yep. Then
Alrighty.
on Monday or Tuesday, I'll reconsider reducing that sentence. But I also want you to see someone from community mental health. And I'm not certain at 3 o'clock on Friday I'm going to be able to get that done. So you're going to stay in over the weekend for sure. Okay.
Okay.
All right. Thank you. We'll be adjourned. Let's take this time to get yourself straightened around.
Yes, Your Honor.
All right. Thank you.
Thank you, Your Honor. That does conclude the city matters, Your Honor. Thank you all.
All right. We have one. Thank you. Yes, we have one more, Mr. Bowman. They had to go get him.
Your Honor, can I bring the other two parties in just to let them know it's going a little longer than anticipated?
Yes.
I work on.
Mr. Courier, Mr. Fulcher, good afternoon. Thank you for your patience. I have one more of the jail cases that we have to deal with, so we're going to have you on mute. But I want you to be stay right put, and then I'll take care of the last case that I have for criminal, and then we'll start with your case. Okay?
Thank you much.
Thank you. Good afternoon, sir. Please state your name for the record.
Gage Bowman.
All right. We are on the record, the People's State of Michigan versus Gage Samuel Bowman. This is file 21-0629FY. Counsel, identify yourself for the record.
Joseph Amon on behalf of the people, Your Honor.
Daniel Duke, on behalf of Gage Bowman for the arraignment.
All right. Today's time and date set for an arraignment. Mr. Bowman, the attorney, Mr. Duke, the attorney here for you today is here just for this hearing. If you wish to have a lawyer after, today, you will either have to hire one or request a court-appointed attorney. Do you understand?
Yes, Your Honor.
Okay. In this case, sir, you are on the record on this file. You are charged with 2 crimes. I'm going to show them onto the computer screen so that you can see them. Right now it's a blank page, but we'll get it. Can you see the documents now, sir?
Yes, Your Honor.
All right. You are charged, and I'm going to look over to the right computer screen. In this case, sir, you're charged. The allegations are from October 3rd, 2017 to March 23rd, 2020. It is alleged in this case that in count 1, you did engage in sexual penetration, the penis to the anus with a child under age 13. That's in violation of 750.520B1A. If you're convicted of that crime, it is a felony. It is punishable by up to life or any term of years, and mandatory lifetime electronic monitoring would be required if you're convicted of this crime, and AIDS and STD testing and DNA must be taken upon arrest. The court may impose consecutive sentencings under 750.520B3. In count 2, you're charged with criminal sexual conduct in the first degree with a person under the age of 13. That it is alleged at an address at 700 Village East in the time period of October 3rd, 2017 to March 23rd, 2020 in the city and county of Midland, the same location that there was a child. The allegations are that you did engage in sexual penetration, penis to anus, with a child of under 13 years of age. If you're convicted of that crime, again, as a felony, punishable by up to life or any term of years, mandatory life electronic monitoring, and mandatory AIDS, STD testing and DNA to be taken upon arrest. Do you understand the charges that I've just read to you and the maximum penalties?
Yes, Your Honor.
All right, Mr. Duke, how would you advise your client to plead to this charge?
Not guilty, Your Honor.
Not guilty plea will be entered in the records of the court. Mr. Bowman, your next hearing date will be on June 22nd at 1 o'clock. And your preliminary examination, if it goes, is currently scheduled for June 29th at 3 o'clock. Are you planning on hiring your own attorney or requesting a court-appointed attorney, sir?
Requesting one, Your Honor.
All right. Are you currently employed?
No, Your Honor.
How old are you?
17.
Are you a student?
Yes, Your Honor.
Where are you a student at?
Wendover High School.
Okay. And your address?
2018 Jefferson Avenue, Midland, Michigan.
Who do you live there with?
My mom, mother, and stepdad, Your Honor.
Your mother and stepdad. All right. Without getting into much of the details, I'm trying to make a determination because there's going to be no contact with the victim in this case. I don't
Yes, Your
know
Honor.
if that person, AW is the initials, if AW lives the same place at 2018 Jefferson Avenue.
No, Your Honor.
Okay. All right. I'm going to appoint an attorney for the defendant in this case. I presume you're not independently wealthy, so you would need the assistance of an attorney, or your parents would have to hire an attorney for you that you don't have the funds. Would you agree?
Yes, Your Honor.
Okay. Mr. Duke, currently there's no bond because of the criminal sexual conduct first degree under 6.106B. I will let you make an argument regarding bond if you wish.
Thank you, Your Honor. Unfortunately, Gage is not going to have any kind of money to post a bond. We request a personal recognizance bond or a low reasonable cash bond. These events are supposedly ended in March of 2020, a little over a year ago. Gage is now 17 years old by my math. He would have been 15 or 16, 14 when this happened. I don't believe there's any recent contact with the alleged victim in this particular case. So I believe, this ended, whatever was going on, that Gage is not going to have any contact with that person. As part of any bond conditions, it could include him not having any contact with anybody under 17 to ensure that this sort of thing couldn't happen again. But we would request respectfully a personal recognizance bond. I understand the seriousness of the charges, or a reasonable cash bond.
Mr. Raymond.
Your Honor, as previously stated under the court rule, and because it's a criminal sexual conduct first degree charge, the court has the opportunity or the right to deny bond. We would ask that stay that way. We have a case here that went on with an individual under the age of 13 for about 3.5 years, was sodomizing that individual. And we also have statements from the victim that this was forced on him. He wasn't a willing participant. And on top of that, we have a confession from the defendant that this did in fact happen. So based on all that, Your Honor, we'd ask that he remain with no bond. Thank you.
The court was the magistrate that reviewed the facts of the case. I was cognizant at the time that I set no bond that the defendant confessed to the acts of multiple times of sodomy. He had indicated that 75% of the time versus 25% of the time is who'd ask. He said that the victim asked for the sexual act 75% of the time, but he did for 25% of the time. The victim at the time was under the age of 13. The defendant would have been 15 years old at that time. Because it happened so many times, and it was indicated by the victim alleged that it was forced anal on him 2 times, and then he made him perform oral sex on him 4 to 5 times, and that the defendant actually acknowledged that there was sexual interactions between the two. There's an admission, so the degree of conviction is high, and is charged as a lifetime offense. 6.106B outlines the factors that the court has to take into consideration. Bond can be denied in a case of criminal sexual conduct in the first degree. The court may deny pretrial release to a defendant charged with a violent felony, and at the time of the commission of the violent felony, the defendant was on probation, parole. He wasn't that. So 6106B1B says the defendant was charged with criminal sexual conduct in the first degree if the court finds proof that the defendant's guilt is evident or the presumption is great. And here, his own admissions would convict him. And we do have the statement of the victim as well. The court then to not issue bond, it says that the court may deny bond, but then if I make a determination that by clear and convincing evidence that the defendant's not likely to flee or present a danger to any other person, I could decide not to. In this case, because it happened over a prolonged period of time and multiple sexual acts, and the defendant's own statements that, at least in his own words, 25% of the time, he's the one that sought it out, I do not think that it meets the clear and convincing standard. So I'm leaving bond denied at this time. Bond can always be reviewed at the probable cause conference and at the preliminary examination. There is an issue, obviously, of the defendant being 15 at the time. He's older than that now, so wasn't charged. So maybe other issues will bring to the court's attention on June 22nd or June 29th. But at this time, bond is denied. Since bond is denied, there's no bond terms to put in place. We'll be adjourned on this case at this time. An attorney is appointed to Mr. Bowman. Thank you.
Thank you, Your Honor.
All right, Katrina, does that finish up